So welcome everyone. Welcome to today's webinar. My name is Connor Spencer, and today we are going to be discussing legal and accounting essentials, protecting your business from day one. So thank you again for everyone for attending. We do have some great content lined up for everyone today. I know there will be potentially some lawyers and accountants on this webinar who maybe will be using it to refresh or reaffirm or learn something new, but for everyone else, for those of you who are a small business owner or have had an established business for sub 5 years, this webinar is very much for you. And the purpose of today's webinar is to give you a bit of a foundational understanding of your legal and accounting essentials, but please bear in mind that it is broad and general advice. While there definitely is some crossover, from business to business, all of you will need advice tailored to your businesses, apples and oranges, which can be obviously dependent on where you're at in your business journey, what industry you're in, what state you're in, any specific short or long-term goals that you may have. And I will be, for anyone who asks, I will be sharing an email, there you go, an email later today about the slides and recordings for those of you who are present. However, to start that conversation, about protecting your business, about doing things right in your business from a legal and tax point, please drop in yes in the webinar, and someone can chat out to reach you via email, which I'll provide now actually in the web chat. Now, for those interested, would strongly recommend speaking to someone if you do have any really specific questions that you think we can help with. What I've also listed in there is a link to our testimonials from clients, link to our Meet the Lawyers page, some of the hot topics we discuss, and then my email, Damin's email, and Tim's email if you guys want to reach out to us directly. But for those of you who are new to Lawpath, who are discovering us for the first time and wondering who are we are an Australian-based online digital legal, accounting, and tax advice platform. We have been operating for close to 10 years now, and helped close to 500,000 small and medium businesses in different capacities within that time frame. So you may have just found us online, you may have come across us from one of our partners, such as some of the different entrepreneurial programs we're affiliated with, from GoDaddy, AusActive, Westpac, or maybe even you've actually been recommended to us by another law firm or accounting practice. We're very much tailor-made for startups and who need that service to fill in the gaps around the legal and accounting knowledge. We believe that all Australian business owners should be able to have affordable access to legal documents and advice that they need to be able to run their business with confidence. And we are a fraction of the cost of the traditional legal system, and yet we can still pay you a very senior legal experts and chartered accountants. And we've even partnered with Amazon and built one of the world's largest legal AI systems as well. So there's a whole host of legal and accounting topics we cover, and I'll briefly touch on those towards the end of the webinar. And as we will as well have an exclusive webinar offer to attendees at the end. But what we'll be discussing, what Tim and Damin will typically be discussing, is business structures and what they mean for you, legal considerations in your first year, accounting best practices from day one, and ATO and ASIC obligations. And then we will have a Q&A and a special offer at the end. So if you guys would like to ask Damin and Tim any specific questions, please submit those in the Q&A section and not in the general chat bot, as it is likely to be missed. And a bit about who will be actually going through the agenda. We are very fortunate to be joined by Damin Murdock and Tim Quinn today. So Damin is Lawpath's principal lawyer. And if anyone wants to view our Meet the Lawyers page on our website, it's one of the links I've shared in the chat. And you can see our lawyers who deal with our legal advice plan clients. And you'll see, for example, Damin has a 5 out of 5 star rating, over 300 reviews. He's overseen various high-profile intellectual property proceedings, such as defending against Nintendo, and he has a very strong ICT legal background. He regularly assists and advises startups and small businesses, which includes all facets of business and commercial law, from contract drafting, negotiating those contracts, and assisting with investors, to employment law, and occupational safety and health policies. And he has advised on capital raisings, transactions valued in excess of 600 million, and has acted for over 2,000 startups. And we're also joined by, as you can see there, Tim Quinn. So Tim's pretty new to the business, but he is a highly qualified chartered accountant with 17 years of professional experience in tax and business advisory at all stages of the business life cycle, from startup to exit. And he has run tax divisions at directors level. He has extensive experience supporting entrepreneurial clients, meeting those tax obligations and advising them on a tax system that works best for them and for their business. So needless to say, they're both extremely qualified. If anyone actually is behind on their tax lodgements and BAS lodgements from last financial year, we can, just before the 15th, get those done for you. Tim will be your man there. We will have an offer on the tax plan or tax compliance at the end. But that's enough from me. I'll hand things over to Damin and Tim, or Damin first, I believe.
Perfect. Thank you very much. Is my video up there? If not, that's fine. I can't see myself. All right, so we're going to be talking about business structures, the main documents that you're looking for as a startup, and why you need those documents. And then what we'll do is we'll maybe ask Tim some questions and put him on the spot potentially. So the first thing is we're looking at business structures. And so some of you might just started a landscaping business and started out as a sole trader. And someone's just asked if I can turn my volume up. Let me see if that's possible. No, not while I'm in here, sorry. Can you hear me okay, Connor?
Yeah, I can hear you clearly.
All right, that's fine. All right, so so you might have started a landscaping business. You might have started off as a sole trader, and you're looking to bring on people. You're looking at possibly buying more equipment. You might want some investors to come in. The sole trader structure doesn't necessarily give you that opportunity. It doesn't normally give you an opportunity to bring in investors, possibly give some of your shares away to your employees. But from a sole trader perspective, it's super easy. So you just get an Australian business number. You might get a trading name, so you can start going as Joe's Sole Trader or as Joel's Landscaping. And it's really easy. You just file your tax returns under your own name. The cost and expense to get it up and running is super simple. So we generally say to most people, if you're just trying to get something off the ground without having to worry about incorporating a company or understanding how the company structure work, and just see whether you can get that product to market or the service to market, sole trader business is a great opportunity to just get it going at the very beginning. Now, the problem then becomes is that if you want to transfer from a sole trader to a company, there are some issues. And a lot of times as you're growing your business, you realize that sole trader might not be the most tax effective structure for you, because you might not be able to get certain government grants that are only available to companies. You might not be able to get the R&D tax incentive. So if you haven't heard of that, the ATO has an R&D tax grant, which is research and development. And there's certain criteria to be eligible for it. And one of those eligibility requirements is to be a company. And in those circumstances, if you do research and development, and as you're doing it, you keep track of all your timesheets and you own the intellectual property and so on, then you might be able to make an application to get 43.5 cents back on every dollar that you spend on that R&D. And if you haven't heard of it and you are doing R&D, first thing you should be doing is talking to Tim or someone else about whether you qualify and whether you can potentially be able to get some of the R&D grant. Now, as a sole trader, it normally doesn't apply to you because a lot of the government grants only apply to companies. The other thing is when you're a sole trader, you can't sell shares in your business. So you might want to bring in your friend or something into the business, but all you're doing is normally doing maybe a profit share agreement or something similar, but it doesn't give you the flexibility of giving them an interest in your business. And the last thing is, as a sole trader, you are running your own business under your own name. So if you have any kind of liability or any kind of risk in running that business, then that risk falls on you personally. And if you were to get sued by someone for not delivering the services or not delivering the product, or damaging someone's property or injuring someone, then you personally are the one that's being sued. Whereas the difference is that a company is a separate legal entity, and so the directors normally aren't personally liable for the product or the service, and instead it's the company that's liable. So the next structure that we look at generally is companies, and companies is you have shares, and shares are owned by the shareholders, and the shareholders are the ones that then appoint a director to the business. And the benefit of having a company is that you can put your mobile phone and your computers and possibly your vehicle and all these expenses into the company, and that offsets your profits, which reduces your tax at the end of the day. The other benefit of it is that the company tax is generally only 25%, which means that you can leave the money in that company and reinvest it back into your company to grow the company, and not distribute the money to yourself, where you're going to end up having to pay income tax, which is a higher rate. So there's some tax benefits there. And then I also talked about the separate legal entity benefit, in the sense that as the separate legal entity, if something happened, the company gets sued, but generally not you personally. And if anything happened, the company can go into liquidation and wind up, but it normally won't affect you personally. Now, there are certain circumstances where you're a director of a company where you can be personally liable. And that's where you don't pay your employees' wages, you don't withhold your employees' tax from their wages, you don't pay superannuation, or you trade insolvent. And insolvent trading is essentially where the definition is where the company can no longer pay its debts as they come due. And if a company is trading while it knows that it cannot pay its debts as it comes due, then a director can be personally liable for that. Now, there's partnerships as well, but partnerships we normally don't touch upon, because we might want to ask Tim about whether he does many partnerships these days, but they're kind of an old school structure that we don't use that often anymore. Primarily, it was used for service industries like lawyers and accountants, and that was because lawyers and accountants weren't allowed to have companies. It had to be owned by the lawyer itself in the partnership, or the accountant in the partnership, and so that's why lawyers and accountants regularly use partnerships. And partnerships is taxed similarly to sole traders. It's basically the joining of two individuals or more, and they get one ABN and they operate under that ABN. But from a tax effect, from a liability effect, is very similar to the sole trader structure. But then they changed the laws where lawyers and accountants were allowed to have companies. So we don't see partnership that often. We always recommend companies over partnerships, because, well, unless there's something very specific in terms of some complex structure. But the reason is that a company just gives you a much more flexibility to bring in investors, bring in partners, bring in employees. From a tax perspective, from a limited liability perspective, it just is a tick, tick, tick for every aspect when you compare the partnership to the company. Now, also, if you look at partnerships, the legislation is generally from 1979. It's very old, whereas the company legislation is from 2001. And the Corporations Act is the most comprehensive legislation in the country, which is the most litigated as well, which means there's lots of case law, lots of guidance. Everybody knows the law, very clear. It's a very robust area of law, whereas partnership law is more contract dispute related. It's mostly based on case law. And so we try to generally steer clear of that. Now, trusts are a little bit more complicated. It's a more complicated structure, but it's good for you to know what it is. And we have a YouTube video on trusts. So We'll give you a very brief overview right now, but if you're interested in it, you can go to our YouTube channel and you can look at our webinars, but you can also look at our videos on this point. And the trust video is about 7 minutes just explaining it. But what it is you can kind of think of it as a contract, and the contract basically says there's an appointer, a trustee, a settlor, and a beneficiary. The appointer is the person that has the ultimate control of the trust, and it gets to choose to appoint or remove the trustee. Now, the trustee is the person or company that has the day-to-day management. Think of it like the CEO of the trust. And what it does is it basically decides what contracts are going to be signed and signs the contracts on behalf of the trust, which beneficiary is going to get distributions from the assets of the trust, and it makes all the day-to-day decisions. And the beneficiaries, they're the ones that are entitled to the assets of the trust if the trustee declares that they're entitled to something. And I'll explain this in a second in the next slide, because then we get into more complex corporate structure. So I'll show you this diagram now in the next slide, and it basically explains a more complicated structure, but I'll explain why sometimes we recommend this structure, and it might be something that you might want to consider. So a family trust, the benefit of that is that if you have, let's say, a trading entity, and if that trading entity is the one that enters into all the contracts with the customers, it's the one that's at risk of being sued because it has a contract, it delivers a service, it delivers a product. That product or service ends up being defective, you're sued. The trading company might end up deciding that they're just going to wind up. And if they do, it doesn't affect you as a person generally, and it's not going to affect possibly all your assets, because what we do is we say the trading company enters into all the contracts with the customers, and then the trading company is 100% owned by the holding company. And the holding company is 100% owned by your family trust. And you put all your assets in your holding company. So if you're developing software, you put your software in the holding company. If you're buying property, you put the property in the holding company. If you're buying equipment and so on, it all goes in the holding company. And then what you do is you enter into a license agreement that licenses the asset down to the trading company for the trading company to then use. So that if the trading company is ever sued, it doesn't actually own the assets that it's trying to commercialize, the holding company does. So if the trading company then goes into liquidation, the holding company can step in and take back its equipment, its software, its property, or whatever it is, because it's ultimately the owner of it, and it has a license agreement that says that if the trading company was to go insolvent or default under the license agreement, then the holding company can claw everything back. Now, another thing that's important is that that's a related party transaction. That's between a holding company and a trading company. And as a related party transaction, a liquidator might not recognize a related party transaction. So if you have that kind of structure, you want to register what's called a personal property security registration in favor of the holding company over the trading company. And the reason you do that is that if a liquidator was ever appointed to a trading company, the trading company goes into liquidation, the liquidator takes control of all the assets temporarily, and then they do a search on all the assets, and they can see, based on their search, that the holding company is the first ranking secured creditor holding all those assets. And that means the liquidator can't deal with those assets, and they have to transfer them over to the holding company. Now, this might be all very complex, and you might not know what I'm talking about right now, but I just wanted to go from very basic to a little bit more complex. And if you have any questions, again, you can go to our YouTube channel. We talk about corporate structuring in more detail as well. But finally, I just want to mention about the family trust. If your trading company makes a bunch of money, let's say it has $100,000 worth of profit, it then pays that profit as a dividend to the holding company. And then that holding company then pays that dividend to the family trust. And so what happens is that the trading company might pay 25% tax on that $100,000. So there's $70,000 left over. And then when it pays that $75,000 to the holding company, and then the holding company pays that to the trading company or to the family trust, the family trust then distributes that $75,000 to its beneficiaries. And it's what's called a franked dividend. So what that means is that there's 25% tax already taxed on the $100,000. So when it goes to the beneficiaries, they only have to pay the gap between their normal income bracket and the amount that's already been paid. So if you're at a 40% tax bracket and 25% tax has already been paid, then there's only 15% tax that has to be paid on that 75,000 when it goes to the beneficiaries. So it gives you a bit of a tax benefit, because if you have children or a spouse, you can distribute it amongst your family trust to your different family members, so that the 75,000 is not just going to you personally, but you might be distributing it between other beneficiaries. So it gives you what's called basically an ability to spread out your tax amongst different people. So there's a benefit there from a tax perspective. But more importantly, if the family trust holds all the shares in that holding company, then it's a separate legal entity as well. So if anything ever happened to you personally, as a director being personally sued, or you go bankrupt, because you've gone bankrupt, your assets can now be taken control of by the trustee. But if you hold all your shares in a family trust, they're outside of the trustee's asset pool, which means that the shares in your business are also protected. So that's just getting a little bit into a more complex structure, but we'll keep on going, and I'll try to pass it over to Tim as quick as I can. Now, when we look at documents and contracts that you want to be having in the first year, that when you started off as a new business, you want to make sure you get your terms and conditions in place. You want to have a shareholders agreement if you have more than one shareholder. So if you're entering into business with another person, you want to deal with that. Insurance, and then we'll look at employee and contractor, and then website legals as well. So we'll just move to the next website or next page, and we'll talk about the terms of service. Oh, we'll talk about the shareholders agreement. So a shareholders agreement essentially is it deals with the relationship between the shareholders of the business. So if you have more than one shareholder in your business, you definitely want a shareholders agreement. Now, the most common dispute that we normally deal with is that there's three people that decide to go in and start a new company, for instance, and they all get 33% shares. And it might be that there's an agreement that the software developer will quit his job early or her job early, and she'll start developing that software. And the other two are going to jump into the company once the software is developed. And so the software developer is building. It's taking longer to build, but that person's not taking any wage. And the other two people are still working. And then finally, once the software is ready to launch, the other people quit their jobs. They all start their business together, and one person's not pulling their weight. And then that one person decides, you know what, I'm not gonna do anything, and I just quit this business completely. Now, if you've given 33% shares to everybody, and you don't have any agreement in place, you can't take those shares away. So they might have worked in the business for 1 week or 1 month, but you can't take their shares away unless you have an agreement in place. And normally that agreement is in a shareholders agreement. And a shareholders agreement can have what's called reverse vesting conditions, which say, we're going to give all the co-founders 33% of the business now, but you all have to earn your shares by working in the business for 3 years. And over 3 years is 36 months. And over those 36 months, month on month, 1 divided by 36, you'll earn your 33% ownership. And if you quit after 12 months, then you've only earned 12 divided by 36. So you've only earned 1/3 of your actual shares, and the other 2/3 can be bought back. So it gives you an ability to be able to buy back shares if you're giving shares to people where there's an expectation that they're going to work in the business. But if you don't have that, then you're not going to be able to take the shares back. The other important thing about a shareholders agreement is that if you're the founder and you want some kind of control, you can get founders' rights, which basically says, even if you are under 50% of the business, you can still appoint a director. You still have the veto right over certain powers, like the other directors need to come to you to get your approval as the founder to issue shares, borrow money, fire people, um, um, enter into any kind of debt, things like that. So it gives you a bit of a control over the business, even though you might lose control from a shareholding perspective. From a contractual perspective, you have these founders' rights that gives you protection. And but the most important thing is dispute resolution. The Corporations Act is a federal law, and as a federal law, generally the only jurisdiction in terms of courts that can deal with federal law is the federal court or the Supreme Court of your state. And the minute I mention either of those, we're normally talking about a lot of money, because the filing fee is about $2,000 to $3,000 just to start a case. You normally need a solicitor, you normally need a barrister, and it's very expensive. Whereas the shareholders agreement has a dispute resolution clause that will normally say before anyone goes to court, you have to lock yourself in a room for 8 hours with the mediator, and you have to try to reach a resolution. And a lot of the times, a resolution is reached when you have an 8 hour long dispute resolution process by way of mediation. So shareholders agreements, very important. Again, you can go to our YouTube channel and find out a little bit more about that, more about founders rights and different kinds of classes of shares and things like that. When we look at terms of service, the most important aspect of a terms of service is being clear. All legal disputes are almost always about misunderstanding, lack of communication, misunderstanding what's included, what's excluded. What do you guys actually understand what each party understands the transaction to be? So when you look at reaching an agreement, there's an offer, there's acceptance, there are a meeting of minds and consideration. Someone's giving up something to get something. And the meeting of the minds is important because you normally have a written agreement to make sure that both parties understand what they're actually getting into. Whereas with a verbal agreement, sometimes you can't prove it, which means that as a lawyer, we say the contract's not legally enforceable because it's vague, ambiguous, or uncertain, because that contract's meeting the main element, which is it's so vague we don't even know what it is, so we can't enforce the actual contract based on a handshake deal. And that's why we have written agreements. Now, I'm probably going over my time because we got to give Tim some time to get into this, but when you have a website that has a tick box, that's a click wrap agreement. And by people ticking accept, that is legally binding document in Australia. But if you don't have that tick box, it's a browse wrap, and it's only going to be legally binding if you've specifically told people of the existence of it and where it's located, and that they actually knew that those terms actually applied. So if you just have terms on your website and then someone does something, you say, oh, well, those are terms. They could just say, well, I didn't know they existed. So you got to actually prove that they existed, that they knew about it, and you brought it to their attention to be legally binding. In November last year, they've made unfair contract terms much more enforceable. So not only if you have an unfair contract term, it could be not legally valid. Also, if you have an unfair contract term and you try to enforce it, they can find anyone involved with the enforcement of an unlawful clause to be personally liable for damages as well. Generally, unfair contract terms is when the contract is a standard form contract, like one on your website, and it's not balanced. I can terminate whatever I want. You can't terminate. You're in a locked-in contract for 5 years, and you can't get out. And if you try to get out early, we're going to charge you a penalty. Penalty clauses, automatic renewal clauses, locked-in contracts, not similar limited liability, indemnity, and termination clauses. Those are mainly the ones that are being focused on at the moment. So if you think that you have an imbalanced contract on your website, or if you drafted it in that way saying, well, it doesn't really matter because no one ever reads it, it does matter because of the unfair contracts under the Australian consumer law. And if your terms and conditions say, I'm not liable for anything, that's an exclusion clause and it's not legally binding. So normally your clause will say, to the maximum extent permitted by law and without excluding any Australian consumer guarantees. This is how we limit our liability. So that's it for that one. Now, in terms of insurances, if you're running a company, you normally have professional indemnity insurance that covers your professional services. Public liability insurance, if you're taking control of an environment, you're a personal trainer, you don't have an office, but you train in the park and you're in control of that environment, and someone twists and falls and hurts their ankle, you should have public liability insurance for the slip and fall. It's basically your slip and fall insurance. So public liability, slip and fall, professional indemnity if your services are defective, product liability if you're selling products, and that is also important. But work cover is mandatory by law, and it's criminal not to have it. So if you have employees, you have to have workers' compensation insurance. It's not that expensive, and it basically covers your staff if they get injured at work by getting in a car accident on the way to work, getting hit by a bus on going home, or psychological, physical injuries in the workplace. And that's it for insurance. And then employee contractor, just if you're going to have an employment contract, make sure you look at non-solicitation clauses. That's to prevent your employees from taking your existing customers, suppliers, and employees. Possibly a restraint of trade clause, which says that they can't have a competitive business. Using your confidential information, using your intellectual property, you want to make sure you have those clauses as well. And look at your termination clause. It's very common that people will put it into a employment contract. If either party wants to terminate this employment, we'll give you 4 weeks notice. Well, if you say that and you don't like someone after a week and they're clearly not a good fit, you still have to give them 4 weeks notice or pay them 4 weeks. So it might be that you want to focus on that, saying during the probation period of 3 or 6 months, either party only gives 1 week. And then after that, then it reverts to 4 weeks. Or after that, it reverts to a table that's in section 117 of the Fair Work Act, which is 1 week for 1 year, 2 weeks for 2 to 3 years, 3 weeks for 3 to 4 years, and so on. So, and one of the quick questions I'll talk about, if you have any questions, drop them in the Q&A, but one of the questions just now that popped up is, how long can a restraint be for? So all restraint of trade clauses need to have 3 elements. They have to have a geographical location. They need to have an area that you're restrained in terms of what the restraint is stopping you from doing, and then a period of time. So we normally draft what's called a cascading clause. So we say the geographical location is all of Australia, but if the court finds all of Australia is too broad, then it's Queensland, New South Wales, Victoria. If that's too broad, then it's New South Wales. If that's too broad and the court finds that's not legally enforceable, then it's 100 kilometers from our office. And then the same thing in terms of time. 24 months, 12 months, 9 months, 6 months. And the reason we do that is that a court can cross out your restraint of trade clause on grounds that it either stops someone from being gainfully employed somewhere else, or it's too broad and against public policy and not legally enforceable. And so that's why we have the cascading clause that gives you the best chance of having your restraint clause enforceable. In terms of how long a restraint clause is, it really depends on how senior your employee is. If you have a receptionist or a receptionist, a restraint of trade clause probably won't be legally enforceable at all. But if you have, and you're probably going to have to rely upon the confidentiality and IP clause to protect them or to protect your intellectual property and your confidentiality. But if they're a senior sales role where they're dealing with your customers all the time, 12 months might be reasonable, and it's to give you an opportunity to find someone else to fill in the shoes of that employee after they've left, to recreate that rapport that your previous employee had. And it's basically there to give you a chance to keep your clients. So how long? It depends on the industry. It depends on the seniority of the employee as well. Now, with employees, they're automatically bound by confidentiality, and all the intellectual property they develop is automatically owned by the company if they're developing while they're working. But for a contractor, it's the other way around. For a contractor, all their IP that they create is owned by them. So if you hire any contractors and you don't have a contract, that means everything they're doing is owned by them and it's not owned by you. So it's important that you get a contractor's agreement in place that says that all the intellectual property is owned by your company, and get a good confidentiality, non-solicitation, restraint of trade clause as well. Website legals, we talked about terms of service. I touched upon the website terms and conditions. You need to get a privacy policy too, generally, if you're going to be sharing it, especially if you have a marketplace. Other policies to think of is refund policy, shipping, cancellation, and cookie policy. Lawpath has all these templates on their platform that you can have a look at. But those are just some of the legals that you should be considering if you're going to operate an online marketplace or if you're going to operate online. And I think that's my last slide. So here's some questions. So do you need a corporate structure now that's a little bit complex? Not necessarily, not if you're just starting, but if you're going to restructure later, you could be liable for capital gains tax. Because if you sell your shares from you to you as trustee for your family trust, that's deemed a sale, and there will be capital gains tax potentially. Or if you sell your sole trader business to your new company, that could be deemed a sale of assets, also has capital gains tax ramifications. And also, if you go from sole trader to company, there's a lot of disruption in doing that, because all your customers have signed up to you personally. They all have your personal bank account. But when you convert over to a company, you have a new bank account, you have a new entity, which means you have to assign all your customers across to your new business. You got to assign all the assets across. You got to create new bank accounts, and there can be disruption. And if your contracts don't have an assignment clause, you have to get all your customers to sign a brand new contract. Do you require a shareholders agreement? There's nothing required, like it's not by law you have to have one, but we highly, highly recommend it. And without one, it's going to cost you a lot of money in the future if you don't have one. How do I make sure that you get paid on time? There's no rule that says that you have to get paid on, or have your invoices paid on 30 days. Shorten it down to a minimum of, or a maximum of 14 days. There's no reason to wait 30 days to get paid for your invoices. What do I do if my website or software developer is taking too long? First thing is, if you're going to get software developed, you must have a software development agreement. All software development should be in a stage process, like building a home. It is, you break it down into milestones, you break it down into cost per milestone, you break it down into time limitations per milestone. And as they do a milestone, you test it, you pay them, they move on to the next. If your developer is taking too long, you might be able to rely upon Australian consumer law, because under the ACL, all services have to be done within a reasonable period of time and fit for purpose and done with care, skill, and diligence. So if a software developer is taking too long, refer to your contract. If you have no contract, you're going to have to possibly rely upon the statutory laws. And can you terminate an employee? That's a very broad question. There's various different circumstances where you can, and there's various different circumstances where you cannot without being sued. So you'd have to get some specific advice on that. And I think that's it, and I'll pass it over to Tim.
Thank you very much, Damin. Very illuminating, and I hope I haven't treaded on your toes and answered too many legal questions, as accountants do like to do sometimes. So on to accounting. We've got a lot to cover off. I'll speak quickly. In fact, Connor, if we go straight into the guts of it. Fantastic. Day one, you should be going out and getting your accounting software. It might not be the most exciting thing you've ever done, but trust me, trying to do it 3-6 months down the line and convert your Excel file or your shoebox of receipts into accounting will be more trouble than it's worth. I recommend getting yourself set up nice and early. The wonder of modern accounting packages like MYOB, or you might have heard of Xero or QuickBooks, is that you can link up to your business bank accounts, and I'd say 50% of the job is done from an accounting perspective. All of these softwares are reasonably smart and switched on, and you'll be able to let them do the hard work for you. So they will get what's called a bank feed. Will literally feed straight into your accounting software, and you teach it. You basically say, well, this transaction is this transaction is like this, and that it'll learn from you. So and in terms of some smarts as well about chasing up invoices, you can set up invoices to be collected by email, by text. There's lots of different options there to really reduce the admin load on yourself. And I think there's some terms of an MYOB offer there with our commercial partnership with MYOB, where you can get 6 months for free if you're a new business under 12 months, or 50% off if you're a little bit older. And Connor will share the link in the chat for that. Right, your tax calendar. This is an important one to get across. Just like with the accounting software, get yourself on top of things early. And have that expectation, that natural cadence of it's quarter end, it's time to do my BAS. A BAS, for those of you who don't know, or a business activity statement, is where you record your GST or your PAYGW, which is the tax you withhold on salaries. GST is compulsory for businesses that will have turnover of more than $75,000 a year, or if you're a not-for-profit, then that threshold is doubled. You report and pay your BAS, report and pay GST using your BAS. Most businesses will lodge quarterly. They're beyond a certain level, it is monthly, but most small businesses certainly quarterly. You have to decide early on whether you want to do cash or accrual basis. The difference is cash basis is you can claim your GST credits or pay your GST as it hits your bank or as it leaves your bank, or accruals is on invoice date. Now, which one is best for you is, it depends. If you are in a situation where you receive big invoices, big payable invoices, and you'd like to claim the GST credits on that upfront before you've even paid the invoice, then accruals is better. Cash might be better for you if the reverse is true. You can still voluntarily register for GST. Some people do so because they might have more GST credits to receive than they would to pay. Or perhaps it's because in business it's just expected. And if you issue an invoice without GST, they might think you've made a mistake. So we do see people voluntarily register as well. Your business tax return. So that's your year-end bit of work. It usually comes off the back of doing your financial statements. Again, if you've set yourself up in MYOB or in Xero, a lot of the work is done. Your accountant will then come in and tidy things up and get you done for year-end. Off the back of your financial statements, which tells you how the business went, what the business has, and things like that. Off the back of that, the business tax return is very closely linked to the information on those financial statements. Your company tax rate for most small businesses is now 25%. It's 30% for the big dogs out there, but for 25% for everyone else, and that's been the case for a few years. In Australia, tax payable on profits, not on revenue, which is fairly common. I would say, do speak to your accountant and your business advisor on how to get funds out of the company. It's probably the most common question we have at Lawpath is, do I put myself on salary? Do I take dividends? And again, the answer is, it depends. Unfortunately, I did already have to type that once in the chat, but it's true. It'll depend a lot on your personal circumstances. There are more tax effective ways of doing it than salary, I would say. But if you're out there looking for a mortgage or trying to remortgage, banks generally prefer or understand PAYG salaries better. So it might be more beneficial for you to stay on payroll. Also, going to dividends and other ways of deferred tax payments require a level of diligence. It requires you to basically park the tax that you're going to have to pay. Whereas if you're on salary, it's done for you. Superannuation is compulsory for all employees now. It used to be only above a certain threshold, but now it's 11.5% of wages must be paid quarterly to every employee's superannuation fund. and that rate will keep going up to 12%, I believe, next year, and then they'll take a pause. It used to be 9%. Back in the day, it was 3%. It's only been going one way, obviously, because the government would rather you self-fund your retirement than having to pay you a pension. Yes, again, just why is it so important to get this right? I would say day one, if you start to model yourself as a model taxpayer. The reason being, you might need to lean on the ATO down the line. You might need what's called a payment plan if you can't pay off an entire tax payment in one fell swoop. If you have been a model taxpayer and you're reporting on time, you're paying your bills on time, you're interacting with the ATO, or more importantly, your accountant is, you are much more likely to get good terms on your repayment plan. We've seen that the ATO used to be seen as a bit of a soft touch, where you could always just put them off indefinitely and pay as late as you felt like it. That's really starting to tighten up in recent months. So you have to be sort of top of the pile and a good taxpayer if you're going to utilize that. Budgeting, it's a big one. It's really hard. I think we're going to recommend here that you do 2 budgets. You do what you think of as a realistic budget, and you do what you think of as a worst case scenario budget. In reality, as things shift, you'll often see your best laid plans are laid to waste, and often it tends to be, particularly in the early days of your budget, more towards the worst case scenario. You've always got to build yourself in enough fat to expect the unexpected. You don't know when your business is going to need more expenditure than you'd have predicted. You don't know when you individually might have issues. I've seen some dentist bills pop up for clients in the tens of thousands that would be terrifying for any small business owner if they knew they had to pay for. Just I do recommend that you give yourself a negative outlook on your business. Obviously hope for the best, but just expect the worst. Some budgeting mistakes we do see people make sure you factor in GST and taxes on salaries. From a cash flow perspective, know when these are going to hit as well. You'll have to you have to be in a position, not just at year end that you've made a profit, but along the way, various peaks and troughs. Understand when your payments come out, when your cash comes in. Make sure you've really factored in all of that timing issue. Don't forget, if you've got loans, there'll be interest to pay, and interest rates are only going one way. So make sure you've factored that in. And think about things like the cost of replacements. If you've got tools, you might consider them a one-off expense that you don't need to budget for, but of course they will degrade over time, and you might need to replace them. And yes, you can, if you're using your MYOB or your Xero, you can log that, you can sort of lob that budget in there, and you can basically see how you're going against actuals, which is very, it can be a painful process to look back and see where you've got your expectations wrong, but it will help you build next year's budget all the better. Yeah, there we go. It's the most common question. How do you pay yourself? Like I said, it depends. If you use what I would call the gold standard of the small business structure, which I think Damin already referred to, the idea of trading company, holding company, trust, you've given yourself a lot of flexibility. Flexibility is really important when it comes to tax effectiveness. The ability to move levers sometimes after the fact, while we're wrapping up year end, is really powerful. Depending on your family circumstance, there might be a non-working partner who can really benefit from a trust distribution. It gives yourself that flexibility. Just depending on your business profits, obviously. Like I said, the downside to that is it can be difficult to prove to a bank that you have a stable income if you're only getting once a year distributions. And what's the personal taxable income? Yeah, so ultimately, any way that you take money out of your business, you might think of it as yours. It is your money, but it just hasn't been taxed yet. So whether you're declaring yourself a dividend or whether you think you can just borrow from the company and pay it back, there will be tax consequences that you individually will wear, but they are still manageable, and they are definitely something that with flexibility can be minimized, legally, of course. Record keeping, it's not fun, it's not exciting. Please do it up front. If you try and do it down the line, you'll be kicking yourself in the pants. It is really hard to remember what you did last month or last week sometimes when you're running a small business. Get yourself a digital filing system, whatever it is, a Google Drive, a OneDrive from Microsoft, and put everything in there. Even if it's imperfect, keep everything you get so that you can come back, worst case scenario, and search for them. There are minimum requirements for those record keeping of between 5 and 7 years. Basically, keep everything you can and keep it digitally, because don't put it in a moldy shoebox. What are the benefits other than the fact that you have to do it and it's legally required? It's running a business is garbage in, garbage out. If you don't keep accurate records, you don't know how your business is going. The number of startups I've seen that have fallen over because of imperfect records or less than imperfect, terrible record keeping, where you might think, I can see how much money is in the bank, I know the business is safe. But if you haven't kept your records, if you don't know what bills are coming, if you haven't factored in your tax payments, you can 2 years down the track get a very rude love letter from the ATO. They put it in big red text so you can't miss it, and they can basically put a statement of demand out on you that you must pay. If you can't address that, either by paying it or successfully challenging it using your good records, you are going to come a cropper. So it's very, very important to keep all of that information. Yeah, in terms of bookkeeping, if you can hire a bookkeeper, or if you fancy rolling up your sleeves and giving it a crack yourself, which I do recommend to a lot of small businesses these days, if you use a good accounting system, again, the work can be much easier. It can be done for you to an extent. You can throw in your payable invoices. It will remind you when to pay. You can basically set up systems with a little bit of elbow grease that will save you a lot of pain down the line, and particularly invoicing is a sure sign of that. You can link, even in Xero, very simply to payment gateways. All of the big banks, but particularly Westpac is very good at this. They have really good small business banking opportunities where you can link everything in and receive payment nice and easily for your customers. Whenever you're ready, Connor. Bank reconciliations, that's just that process of auto categorization that we talked about, and making it really easy to keep your accounts up to date. Setting up employees, another very common question. How do we do it? Again, I'm going to keep pushing you back towards your accounting software. A lot of this stuff is automated these days. It used to be a very painful process. If anyone remembers those red and yellow bits of paper, the tax file number declarations, and filing all of them and writing various letters to the ATO, you don't need to do that anymore. You can do these declarations online through any reputable payroll reporting software. Just do make sure that you capture the important information about HEX and tax-free thresholds. Otherwise, your employees will get a rude surprise when they hit up for their HEX repayment at the end of the year, as recently happened to my wife. It is not much fun. Better to have it withdrawn from you every month or every fortnight. Superannuation details at this point, you've got to lob one in. It is compulsory from an employer's perspective to provide a superannuation fund. A lot of people these days already will have one. We have this concept of portable superannuation now that wasn't there for many years. If they don't provide you details, you can set them up a default fund, and there's lots of low fee default MySuper options that you can look for. All of the big industry funds will have one, and they're very low fees. Do make sure you set up your leave provisions. You might think, what's the difference between 7.6 hours and 8 hours? Trust me, when you're trying to reconcile an employee that's been there for 10 years and they argue with you about how much leave they've taken, if you've left that 0.4 hours a day difference in, it could be very material, it could be very costly. So do just make sure you've set yourself up nicely in there. Superannuation these days is very easy to pay. The government wants it to be easy for small businesses. There is a clearinghouse with the ATO for small employers where you can just put one easy payment once a quarter. If you've set it up correctly, it will then funnel those funds out to the correct superannuation fund. So it's much easier than it used to be. No excuses not to do it. Thank you, Connor. Yeah, so like we mentioned, it's due quarterly. You can pay it more often. These days, more employers are paying it monthly than they used to. It's due on the 28th of the month after the quarter. So for a June quarter, it'll be July 28th, and the quarter coming up end of September, make sure it's paid in October. Do use the Small Business Clearinghouse. I recommend it. It's very, very easy to use. Do get it right, and I'm sure this is probably on the next slide, but the penalties for not lodging super on time are no joke. There's a superannuation guarantee charge, which is prohibitive, and it can actually stop you from having tax effective super payments as well, because it can restrict you from claiming a tax benefit like all other expenses if you're paying it late. The ATO has very good records, very good data matching these days. If you're not paying employees, they will know about it and they will hit you up for a lot of penalties. So please, if you can only pay one bill, if you're strapped for cash, make sure it's to your superannuation before all others, I would say. It's very, very important. Thank you, Connor. Yes, your ongoing reporting, like I've already said. Why is it important? Well, it's compulsory. Why else is it important? Because you don't know what you don't know. Keeping your records nice and tight from day one will really will help you model what's coming next. So you'll really get it's not just a historical thing. Good record keeping is going to help you budget and manage your business. So again, completely recommend it. What else do you need to have a think about? You guys would probably know more than me. Don't listen to your accountant telling you how to do marketing, but don't leave it undone. Don't leave it unsaid. Do have a marketing plan. Think about how you're going to sell, to who, and have some different options. If you're B2B or B2C, think about what your markets look like. Get your website set up. It's as easy as anything these days to go on to GoDaddy and pay a few bucks. You've got your domain name, you've got some cheap hosting. Just go for it. Setting up a WordPress or a Shopify is as easy as anything. Create your brand guidelines. Understand how your brand is going to operate and what that looks like compared to everything else. Set up your socials if you're that way inclined, or pay someone younger than you to do it for you. I think any old 12-year-old these days can run an Instagram account, and they're probably cheaper as well. Yeah, again, think about your customers and how you're reaching them, whether it's online directories or something else. And think about who you want to partner with. Don't think that you have to do this alone. There are options out there to be really strategic with your thinking, and some fellow businesses that you can work with. Don't forget about ASIC, the corporate regulator. They're probably my least favorite regulator to deal with. The ATO are fun and rainbows and lollipops by comparison. ASIC will slap you with a fee just for looking at them wrong, and the penalties are very, very hard to undo. There's not much flexibility with them. Your annual review statement, if nothing's changed, if your shareholders haven't changed, it's just a payment and there's nothing to it. It's the ASIC compliance team here at Lawpath certainly know what they're doing as well. Just get it taken care of. It's one of those irritating things that is no fun and will provide you no value, but if you do it wrong, you'll get hit really hard. In terms of what do you have to do at year end, your tax accountant really should have you covered for this. They'll provide you sample resolutions and templates. It's a very simple process at year end, just to say, look, we're solvent. You know, it's important. Don't do it without turning your mind to it. But if you've thought about your solvency, do the resolution on time. Make sure you just keep records, like I said, put it in that nice digital file. And of course, when you do get your annual statement, now's the time to double check, because if things are wrong, if you have to go back in time and fix them, they are expensive. So just get it done at the time. Over back to Connor, I think.
Awesome. Thanks, Tim, and thanks, Damin. I'm really conscious of time, and I do want to jump into the Q&A as quickly as possible. So if you guys do have any additional questions, now would be the perfect moment to pop them into the Q&A chat. I know Tim will answer a few of those live now as he's going. Yes, Meg, we will be sharing a recording later today via a few emails. But just a quick bit on how we can help. I'll get through this as quickly as possible. So if you guys do have questions in a bit more detail, and if we'll be the right fit for your business, do shoot me an email or get in touch with us. I'm happy to have a bit more of a lengthy discussion to what we can offer you there. But just a quick look at some of the poll questions and seeing a bit what you guys have been answering there. Obviously, most people have registered a company or considering a company registration. Perhaps after today and some of the content Damin in particular was sharing earlier, you guys may want to have a chat with us in a bit more detail to what's going to be the right fit, whether it's a company or a holding company plus your trading company, or even a trust structure as well. I can see a lot of people are still yet to hire an accountant or hire a lawyer. And so we'd love to basically fill in that gap for you and provide you with both. Our lawyers and lawyers and accountants do liaison with each other. And so we'd love to keep that all under one roof for you. And then I think finally, the other thing, which is always a huge concern for a lot of people, which is around GST registration, tax deductions, and tax compliance. It's something which is very much our bread and butter. If you're looking for some really solid advice on that, do get in touch and we'll be happy to have that chat with you guys. And really interesting, like quite a few people are more comfortable with the ad hoc pay-as-you-go option when it comes to the legal or accounting support. Obviously, what we offer is that subscription-based model, which keeps your legal and accounting fees to an absolute bare minimum. And what we want to do in terms of ongoing legal assistance is year-round support. We actually looked at some of the statistics from the Australian Bureau of Statistics, and we were just looking at some what they released in terms of business entries and exit data, just looking at the 3-year survival rate of businesses. And we actually saw, interestingly enough, you guys might have already heard this stat, but the average Australian business survives past 3 years is 51%. If that business was with Lawpath, they actually had a survival rate of 64%. So they were 25% more likely to survive the 3-year mark when they were actually using Lawpath. And the same, if anyone wants to go on, quickly Google ATO Small Findings Inquiry, I think it's called. You'll see there they state really clearly in black and white that the businesses that interact on a regular basis with their accountants, for example, tend to fare better when it comes to compliance or meeting their tax obligations. But a quick bit on how we can help. This might be pretty familiar to a few of you guys on the webinar now. These are our legal plans, essential and legal advice. We also have an accounting advice and tax compliance plan, which is all that hands-on work. And we now have actually introduced some bundle options, so you can really mix and match depending on what you think is the best fit for your business and also the most cost-effective plan for your business. And the most simplistic version of it is what we're offering is some innovative online legal and accounting services designed to simplify any legal process you have for your small to medium-sized business, whether that's through the document builder, through our unlimited consultations on the legal and accounting advice plan, managing your documents, having those documents reviewed, or fulfilling your basic needs for tax compliance. And then if you guys do need anything a bit more niche and high ticket, I mentioned some of the experience Damin has, for example. We also provide some fixed price quotes. So you have really transparent pricing for any additional legal or accounting and tax services that you need for the business. But just to show you guys for today's webinar, I know a few of you will have to jump off. We are offering 30% off on our tax plan. It works out at just $210 per month. With an annual commitment. That will be Tim doing all that hands-on work. So he'll be your dedicated tax agent. You get that initial tax consultation, and he'll be doing your annual and quarterly BAS statements, financial statements, and that annual business tax return. And you guys actually also get a special fiscal year consultation, basically a bit more of a in-depth discussion to kind of go through how your business basically performed in the previous financial year and come up with some strategies to help it perform better this side of the financial year.